All right, so welcome to our June 2022 Lunch and Learn. The topic is immigration, and I will turn it directly over to Laura Graham. She is our presenter today. So Laura, thank you so much for doing this. I so appreciate it. Feel free to introduce yourself and then get started.
No, thank you. Thank you for having me. Many of you look very familiar. So you might have seen this dog and pony show before. There's been some updates. So hopefully you won't find it too tedious. I shared the slides and a brochure or handout with Lauren. She's going to circulate that to you all. So please don't feel like you need to feverishly take notes or screenshots of the screens. All of the materials are coming your way. So you can focus and take notes, but you don't have to take pictures of the screen. We're giving those to you. I am going to attempt to share my screen. All right, Lauren, can you see my slides moving?
Yep, you're all good.
Awesome. So we have a pretty packed agenda in the remaining 58 minutes. I'm not going to go over each of these slides and read them to you or go over everything. One, I know you all are probably very good readers, and two, it's more information than we're going to have available time to cover here today. And so the idea is just to give you some kind of bullet points and background information so you've got it as a future reference. And I'm happy to take questions, follow-up questions by email if we can't get everything addressed here today. So I'm just going to briefly give you some overview about, who we are here at Community Legal Aid Society and what we do. So you have information that's a resource for the youth and the families with whom you work. Then we're just going to touch on kind of the basics, Immigration Law 101, so we know kind of the terms that we're defining here today. Then we're going to go over kind of the pros and cons of having and not having immigration status. And then walk through the main types of cases that immigrant children and youth might have available to them. There are two in particular I'm going to focus on, but there are four main types of victim or abuse-based cases that we'll touch on. And then I'm going to just give a quick overview of maybe other types of immigration relief that might be available to the children and youth with whom you work, and then kind of, back clean up and end the day with just some hot topic issues that come up, concerns, rumors, and things like that when working with non-citizen families. So for folks that don't know me or our agency, Community Legal Aid Society, we've been around since the 40s. In the last decade, and we are a free legal services provider. We're a nonprofit civil legal services law firm. So we're the civil side equivalent of the public defender's office. So we provide free civil legal services to certain populations in Delaware. And the way we do that is through individual representation. We take individual cases that fit within our funding and our grant priorities. So, someone is being evicted, someone needs help with a protection from abuse petition. We will take on those individual cases and represent that client. We also effectuate this by doing community education, and that can include things like this training here today for you all, but it also includes outreach to community members on a more kind of grassroots basis. So going out and talking with families at schools and churches and things like that. And then finally, we effectuate change for our clients by engaging in policy work. So that's anything from changing the policies that a state office or federal office might have, and also doing some legislative or statutory work to change laws that affect our clients. We carry out this work in our three offices. So our Newcastle County office is in Wilmington. That's where I sit most days of the week. We have an office in Kent County that's in Dover on Walker Road. And we have an office in Sussex County in Georgetown, right across from the Walmart. If you're familiar with where Social Security used to be before they moved to Lewis, that's where our office in Sussex is located. In each of those three offices, we have 6 main programs. And I'm going to talk about one program in particular today, that's the immigration program, but we have 6 programs that provide services throughout the state. Our poverty law program represents individuals who are facing termination or eviction from their subsidized, their low-income housing. So your Section 8 vouchers being terminated, or you're being evicted from Delaware State Housing Authority housing. The poverty program would screen those cases. Likewise, individuals who are facing termination, denial, or a reduction in their public benefits, things like Medicaid, SNAP, food stamps, WIC, TANF, cash assistance, our poverty program would handle those types of cases. Our disabilities law program represents adults and children who have physical, developmental, cognitive, or mental health disabilities on any issue that is related to their disability. So anything from special education to being able to access services, whether that's physically, like a client in a wheelchair with mobility issues, but also individuals who are unable to access services because of a mental health impairment. Our elder law program represents individuals who are 60 and older on things like advanced healthcare directives, powers of attorney, contractor fraud, where an agency or an entity is taking an advantage of a person who is elderly, or elderly victims of crime and mistreatment. Our immigration and domestic violence program, we represent survivors of domestic violence, family violence, and other types of crime. For our domestic violence work, that means we represent survivors of family violence on protection from abuse petitions, custody, and some related ancillary issues like divorce. For immigration, the services that we're able to provide are victim-based immigration petitions, and we'll talk about those here today. So U visas, T visas for trafficking victims, Violence Against Women Act or domestic violence, family violence petitions, and special immigrant juvenile status. And one of the things that Lauren's going to circulate is our Spanish English immigration services brochure. That's kind of a good cheat sheet on the services we provide and the basic qualifications for those different types of visas or relief. And then the last 2 programs we have here at CLASI are our fair housing program. So if individuals are being discriminated against in their rental housing or their home ownership based on them being a member of a protected class, and that can be anything from race, gender, religion, nationality, or ethnic origin, then we would investigate and potentially prosecute civilly that discrimination. And then finally, our medical legal partnership program. We work with 7 medical and social service providers throughout the state who refer their patients or participants to us to address their unmet civil legal needs. The one that would be probably most available to the clients with whom you work would be our Division of Public Health Medical Legal Partnership that serves pregnant and postpartum women. And there are many pregnant and postpartum teens with whom you might be working, so they might qualify for services from us under that program. Because there are 3 civil legal services agencies in Delaware, and we kind of divide up the pie of who does what, it can get confusing. So this slide is just a good chart to let you know kind of who does what throughout the state, and how to reach that agency. I still have this pinned on my bulletin board here in the office. It's a good reference sheet of which free civil legal service providers do what types of cases in which of the 3 counties. All right, so we're going to jump right into the basics of immigration law. And I think it's important to define our terms. So when we're talking about immigrants and non-immigrants and citizens, it's helpful to think of 2 groups of people, 2 separate kind of pillars. One is United States citizens, and the other is the everybody else category. With US citizens, what we're talking about, or who we're talking about, are people who were born here in the United States. If you are born on US soil, you are automatically a US citizen. We're talking about people who were born abroad but to American citizen parents who can derive citizenship based on their family ties, or people who were born abroad but have come to the United States and have gone through the process called naturalization, which is the application to become a US citizen. Those are the three ways that someone can be or become a US citizen. The everybody else kind of category or bucket of people is pretty broad. It can include lawful permanent residents, and those are people who have green cards and have the right to live and work in the United States permanently, but they're not US citizens. It can also include non-immigrants, and that term is an immigration kind of technical term or term of art that is someone who is temporary. They have the right to temporarily be in the United States for a specific purpose, whether it's to visit, to be a student, to work for a specific company or fill a shortage occupation, but it's a very temporary stay in the United States that doesn't let them become a citizen. And then finally, we're talking about individuals who lack immigration status in this non-citizen group. That's anyone who entered the country unlawfully. They came across the border without any permission to enter. And that also includes people who did come here with permission. You know, they came on a student visa, they came on a visitor's visa, but then that stay expired and they never left. So they're now out of status. So those are the two kind of groups of people that we're talking about. And why is that important? Well, for many reasons. For our clients, it's important because it dictates what kind of services they can get and what kind of barriers they might face. If you're a US citizen, you're eligible for public benefits. As long as you show that you live in the state and you have the right level of income, you can get SSI, you can get public housing, you can get food stamps. You're eligible for all of those things. If you are a non-citizen, depending on what your status is, you most likely don't qualify for any of those benefits. If you're a US citizen, you have a social security number and the right to work wherever you want. You have the ability to work. If you're a non-citizen, depending on what your status is, you may or may not have a social security number and you may or may not have the ability to work or work wherever you want. Also, kind of with the social security number and status, comes the ability to get a driver's license or state ID in the state. If you're a US citizen, you can get a state ID or a driver's license. If you're not a US citizen, you may or may not be able to get a license or an ID. There's a new-ish phenomenon in Delaware where it's a non-driver privilege card for individuals who lack status, but it's not a driver's license per se. And it's certainly not a TSA or Real ID Act approved ID document. So that's another difference or barrier for citizens versus non-citizens with DMV issues. And finally, US citizens cannot be deported from the United States. If you are not a US citizen, then you may be deported. Even a permanent resident can be stripped of their green card depending on their history and convictions and things like that, and deported from the United States. So only US citizens are safe from removal. So there are big stakes involved. For children and youth who may be in foster care, they may have some remedies or types of relief, visas available to them that would let them get on a path to live and work and or study in the United States permanently. We're going to go over 4 types of cases, but as I mentioned earlier, the 2 main types of relief that I want to focus on are U visas and special immigrant juvenile status. And the reason for that is because those are the most common ones that you're going to see. We hear a lot about trafficking in the news and you know, from law enforcement, but you know, I feel like T visas are kind of like unicorns. We just don't see it a lot. It's you know, your everyday, unfortunately, child abuse, domestic violence that we see the most of. So I'll spend the most time on U visas and SIG. Okay. Oh, and I see a hand.
Yeah, we do have one question, and Joyce, I can just read yours. So the question is, what is a refugee status of like those coming from Ukraine?
Oh, good question, Joyce. I feel like you've skipped ahead in my slides.
If you want to hold that question until you get to it, that's fine.
No, you're totally fine. So refugees are individuals who are outside the United States, who are either persecuted by their government or by groups that their government of their home country can't or won't control. And so, you know, the folks who are Ukrainian nationals are the most recent refugees. If they are designated as a refugee by the UN and the United States abroad, they have the right to come into the United States and get on a path to citizenship. If you're inside the United States already, you don't qualify for refugee status. You might qualify for asylum, which I'll talk about later on, as one of those kind of other types of cases, but you wouldn't qualify for refugee status. It's a good question. All right, and that was the one that was in the chat. So, you know, keep questions coming. I'll just keep rolling until I see a chat pop up or Lauren lets me know that someone has a question. So with the U visa was created almost 22 years ago by Congress, with the idea being that non-citizen survivors or victims of crime are often scared or unwilling to come forward and report the crimes against them because they might fear deportation. Their abuser might have told them that if they call the cops because they're undocumented, they'll get deported. Or they might in their home country have had a bad experience with the police or with corruption with the police. So they're fearful for coming forward and reporting crimes. The idea behind the U visa was to give law enforcement, child protective services, the criminal justice system, the tools they need to kind of encourage and develop a bridge to non-citizen communities to come forward and report crimes. So the idea is to provide humanitarian relief to people who have been victims, but also to give law enforcement or the criminal justice system kind of a carrot to encourage people to come forward and report crimes against them because it helps keep the entire community safe. So there are 4 main requirements to qualify for a U visa, and we're going to kind of go through each of these requirements step by step. But the main requirements are you have to show you are a victim of a crime here in the United States, and it has to be a certain type of crime, a qualifying crime. 2, you have to show that you were injured by the crime and by what happened to you. 3, you have to show that you have information about what happened, you know, the qualifying criminal activity. And then the 4th requirement, which gets back to the purpose of the U visa, is you have to show that you've been cooperative with whatever law enforcement or criminal justice system actor was investigating or prosecuting the crimes that were committed against you. So you have to cooperate and report the crimes. So for the first requirement, showing you're a victim, you know, what do we mean by victim? We mean, you know, kind of the obvious definition, the person who was assaulted, the person who was raped, the person who was directly harmed. But it can also be an indirect victim. You know, so just to give you an example, if a person is, you know, the direct victim is shot and killed or lacks capacity, their spouse or their child can stand in their shoes and seek a U visa. The other thing to keep in mind is if a US citizen child is a victim of sexual assault, they're a US citizen, they don't need a U visa, but their parent who stands in their shoes because that child lacks capacity due to their age, their parent who might be undocumented could qualify for a U visa. And for folks who have been in Delaware for a while, you know, this was most obvious with the Dr. Bradley cases. There were many US citizen children who were victims of his crimes, and their parents who were undocumented stepped up and cooperated with law enforcement in the AG's office, and the parent was able to get a U visa based on them cooperating on their 3-year-old's behalf. So that's kind of a good thing to keep in mind. Even if the child doesn't need status, the parent might be able to seek status based on the child's victimization. And then what do we mean when what's the definition of qualifying crime? So it's any crime that happened in the United States and violates federal, state, or local criminal law. There's a whole list in the U visa statute of kind of broad criminal topics. I have highlighted in red the ones that we see most often with our children and youth clients. But again, you'll see these are broad topics. This doesn't cite like certain portions of the Delaware Criminal Code, which is Title 11. They're kind of broad bad acts. And the key is to fit the bad act that happened to the child, the youth, or their cooperative parent into one of those categories. So domestic violence was one of those categories. There's not just one crime of domestic violence in Delaware. Domestic violence in Delaware is a whole list of crimes that count as domestic violence if they happen between certain people who meet the definition of family. So if a spouse commits offensive touching or assault third against their spouse, that's domestic violence and could qualify the survivor client for domestic violence. Same thing goes for carjacking and robbery. You'll see that felony assault is one of the listed crimes. In Delaware, that's assault first or second degree. Carjacking is just me assaulting or threatening to assault you in first or second degree while I'm taking your car, or me threatening or assaulting you to effectuate the taking of your property, which is robbery. So kind of think broad or big picture when you're thinking about what's a qualifying crime. The other thing to keep in mind here is it doesn't matter necessarily what the defendant or the accused person pleads down to, or if the charges were dropped. So let me give you an example. If I am a child victim of child abuse and my mother ends up pleading down to offensive touching, or the charges get dropped, all that matters is that the crime investigated was a qualifying crime and that I was cooperative. So even if they start out charging a qualifying crime and then they plead down or dismiss the charges later on, what's relevant for me for purposes of a U visa is what was investigated, charged, prosecuted, or sentenced. If any of those have a qualifying crime element, that's what's relevant. So the first requirement, victim of a qualifying crime. Second requirement, I'm injured by that crime. And what does that mean? So it means I've sustained substantial physical or mental harm because of what happened to me. So that's physical injuries, emotional or psychological impairments. And what they're going to look at is the nature of it. How severe was it? How long of a period did it happen to me? And that can include aggravation of pre-existing conditions that I have. So if I am pregnant or a person with a disability, or someone who is already has already been diagnosed with PTSD, and then my perpetrator aggravated those injuries by doing this new crime to me, that can count as sufficient injury. And one thing that's important to keep in mind is things like domestic violence and some child abuse crimes might not be one discrete serious incident. It might be a long pattern of incidents that impair my mental health. And immigration will look at that long pattern and look at the totality of it, as opposed to the one assault where I have a broken jaw. So kind of, again, thinking big picture and trying to prove this. The third requirement is that I show that I have information about the crime. And it's easiest to kind of think about this in the who, what, where, when aspect. So can I answer those questions to the best of my ability to law enforcement or the prosecutor or DFS or whomever the actor is that's investigating the crimes against me? Do I have credible details and knowledge about the crime that might help the investigation or prosecution in any way? A question that frequently comes up is, what if I'm assaulted from behind on the street? And I don't know who it was that did it to me. Maybe does that count as information? Or am I going to have a hard time proving this element? And not to be a lawyer, but the answer is it depends, maybe. If I can tell the officers, well, I was walking down 4th Street and I saw 2 women in black t-shirts. They were about my age and about my weight and height. And then the last thing I remember is hearing someone speak and I woke up on the ground. That's information that's helpful to law enforcement. I might not know who they are or any further details or what they hit me with, but I have information and I'm sharing that information with enforcement. And that has typically been good enough for immigration. The last requirement, which is really kind of the hardest, or I don't want to say most important, but what immigration finds the most important element, is proving cooperation. A victim survivor must cooperate with law enforcement. And again, that gets back to the intent, the congressional intent behind the U visa. If I am unable to cooperate because I'm in a coma, I'm incapacitated because of my age, as long as my parent, guardian ad litem, or court-appointed next friend is cooperating on my behalf, that is sufficient. And it's an or statement. I have to be cooperative in the detection, the investigation, or the prosecution of the crime. So if I'm being as helpful and cooperative as I can be, it's not my fault, or it's not a lack of cooperation if law enforcement has a warrant out for my perpetrator's arrest and can't find him or her. And there's also no requirement that a conviction be secured or won in a case. As long as I've been cooperative, even if the jury finds my perpetrator defendant not guilty, as long as I meet these elements and I've been cooperative, I can still qualify for a U visa. So just some things to keep in mind. We tend to take a broad view and try and advocate that cooperation includes talking to the police, making a 911 call, working with the prosecutor, working with the family court on a protection from abuse order if I've appeared at a hearing and given testimony. So in Delaware, for those who are familiar with the PFA, or protection from abuse, the civil protective order process, if I file a PFA petition and I get a PFA by default with a finding of abuse, meaning I testified, my abuser didn't show up, or after a trial, I get a PFA because the commissioner or judicial officer has found that abuse did happen, I can get a U visa based on that, even if I didn't call the police. Likewise, there are limited cases where the kids department will consider signing a U visa certification certifying my cooperation if I cooperated with their investigation against me or my child and their victimization. So the obvious cooperation is the police, the prosecutor's office, but there are some kind of more subtle, less obvious options that can still count for a U visa. And cooperation means I haven't unreasonably refused to provide assistance. And, as one might guess, reasonably refusing is kind of a moving target. I would say if I'm getting death threats from the defendant, the perpetrator of the crimes against me, and he or she has found me while I'm in protective custody, and so I refuse to show up and testify, that might be probably reasonable that I'm refusing to do that. But me saying to the law enforcement officer or the deputy AG, I'm not going to help you anymore, I'm done, I don't want to cooperate, that's probably not going to be reasonable. So there's this ongoing obligation of the survivor victim to cooperate with the system. So the way that this fourth requirement is required to be proven is every applicant for a U visa has to submit a certification, and it's on a specific form that immigration has, and it has to be signed by the head of the police department or someone that they've designated. It has to be signed by a judge. It has to be signed by a prosecutor or the head of the department, like in the kids department case, the secretary or someone she designates, Trini Parker, currently signs off on these certifications. And what these certifications do say is they say, yes, we certify this person was a victim, we investigated what happened to them, and we certify that they've been cooperative. You cannot apply for a U visa if you don't have this certification. However, just because you have this certification doesn't mean you're automatically going to get a U visa. It's just one piece of required evidence that immigration will consider when making a decision on your case. And the other thing to keep in mind is once, the police, the judge, the prosecutor, Trini sign off on this certification, it's only good for 6 months. And so that means the survivor and their attorney really need to move fairly quickly to get this filed before it expires. And I will just, end with saying, for our clients, we draft this certification for law enforcement, for the judge, for them to review and sign off on. We don't expect them to draft it themselves. So that's something that, the survivor doesn't have to do, the victim doesn't have to do, and the system-based agents don't have to do either. So if I can prove those main requirements, I submit all of my documentation and I get approved for a U visa by immigration, by Homeland Security. What does that get me? Well, it gets me a 4-year work permit and a 4-year temporary status. So I have the right to lawfully live and work in the United States. And with that comes, a social security number and a driver's license. It also, for kind of holistic family unity and support of victim reasons, allows me to petition for non-offending qualifying family members, whether they're here or back in our home country or somewhere else. So just to kind of run through what that means, if I am a 17-year-old victim of rape, I can qualify for a U visa. If I'm married, my non-perpetrating spouse can get status. If I have any children who are undocumented, if they're under 21, they can get status. My parents, if I'm under 21, as long as they're not involved, in this case, as an offender, they can get status. And my siblings, brothers, sisters, whether step or adopted, biological, can also get status if they're under 18 and unmarried. And again, the idea is to really provide holistic familial support to survivors of crime in the United States by keeping the family support unit intact. Again, and the key is, if the perpetrator of the crimes against me is my father or my spouse, they're not going to be able to get status based on what they've done or have been alleged to do. It's non-offending, non-perpetrating family members who can qualify. And I said that the U visa is good for 4 years, but in your 3rd year, so 1 year before your status expires, you can apply for lawful permanent residency. And after you have permanent residency or your green card for a certain period of time, you can apply for citizenship. So the U visa is really the first step in a long path to becoming a US citizen and being here lawfully. And I think, Joyce, you have another question.
Yes, what is the general time frame for doing this and gathering this and getting this information and eventually getting the status?
You're asking all the good questions, Joyce. So it is not fast. Right now, Congress has only allowed by statute immigration to grant 10,000 U visas per year. And so for a lot of years, up until about 2011, we never hit the cap. Starting in 2011, we hit the cap. So they gave out 10,000 U visas nationwide, and then they started making a waiting list. 12 years later, here we are, and the waiting list is over 280,000 people. It is a lot of people. And so that's just until, even if they want to approve you, that's just the wait to actually get your 4-year status. It is taking them 5.5 years to even review your petition and give you a temporary work permit so that you can at least have some ability to work and support yourself and have some sort of quasi-legal status while you're waiting all these years to be able to get a U visa. So I am just going to be, the bearer of realistic bad news here. This is not a quick fix to get a child, a youth, or non-offending family members status quickly. This is a long, drawn-out process. And so that's something you want to keep in mind when we talk about children and youth who are eligible for SIJ, Special Immigrant Juvenile Status, and a U visa, kind of thinking about the timing of things and what might be faster or better for them, for those kids who are dual eligible. All right, let me find my cursor here. Okay, Any questions about U visa before we jump into special immigrant juvenile status?
Hello, I have a question.
Okay, go ahead, Gerald.
Yes, it's about the federal background check that proved that the person entering the country does not have a criminal record here in the United States. I know because I worked on that software database at the FBI, and all immigrants had to show that they do not have they had a clean criminal record coming into the United States.
Absolutely. Yeah, that's a great point. So every one of these types of relief that I'm going to talk about today, every applicant 14 and up has to do a federal background check. They do a fingerprint check that gets run through all the systems. Just because you have an arrest or a conviction does not necessarily mean you will be barred or prohibited from getting an approved case or relief, but they will be aware of it and you have to address it. And there are criteria built into these types of cases that let you know what types of convictions are problematic and are going to be kind of a deal breaker for you getting status, and what types of convictions are potentially waivable or forgivable. But yes, every applicant for every type of status we're going to talk about here today has to undergo a background check. And so if you have, a conviction for felony assault or rape or you're on like an Interpol list for terrorism, you're probably not going to get relief. And that's something that immigration does, not the local law enforcement or family court. Immigration runs those background checks on every single application. So great point. All right, I'm just going to keep on trucking through here. Again, pipe in if you have questions. So the next and most common type of case that you're going to see is special immigrant juvenile status. And this type of case or this status has been around since the 90s, with the idea that children and youth who age out of foster care and lack immigration status are really hard to help plan for, maturity, post-discharge planning. If you don't have a social security number, if you're not able to work or rent an apartment or continue your education after you leave foster care, how do you plan for self-sufficiency and independent living if that child or youth doesn't have any of those tools? So the idea is to provide a type of relief and immigration status to those children and youth aging out of foster care. It has since been expanded, but that's kind of the main crux behind SIDGE. So in order to qualify, you have to show 5 main things. Number 1, that you're a child, and federal immigration law defines a child as someone who is not married, they're single, and they're under 21 years of age. Obviously, Delaware defines a child in most circumstances, absent, special circumstances, as someone who hasn't reached their 18th birthday. So the federal law is a little more generous, but the state law is usually more restrictive, ending at 18 usually. You have to be a child who is physically present in the United States. You cannot apply for this status if you're abroad. You have to be here. The third requirement is that you have to have been declared dependent by your state's juvenile court. So here in Delaware, that's the family court. And the family court has to have legally placed that child or youth in the custody and care of either DFS, which is our state foster care agency, or place them in the care of an individual that the court or entity that the court has appointed. So that can be, a sole custody arrangement with a non-offending parent, or that can be a guardianship arrangement with a non-parent relative or caregiver. You also have to show that your reunification with one or both of your parents, one is enough, but it can also be both, has been found by the court to not be realistic or viable because of that parent's abuse, abandonment, neglect, or dependency. And then finally, you have to show it's not in your best interest, the child, to be returned to your country of last residence. It's better for you, it's in your best interest to remain here. Now, why do I have 3, 4, and 5 kind of bolded and in a different color? And it's because those are the three specific topics and findings that a family court judge in Delaware has to put in an order for the child to be able to apply for SIDGE. So for the U visa, you have to have that certification from the police or the prosecution or DFS to be able to apply for a U visa. For SIDGE, the equivalent is you have to have that predicate order, that form order from family court, laying out these three specific findings. You will not be able to apply for SIDGE if you don't have that. And this is kind of most commonly done in dependency and neglect proceedings, but you can also get this kind of order from a custody case. And again, that's where non-offending, for lack of a better word, parent is seeking sole custody and the court makes these findings. It can also be in a guardianship case where a non-parent is seeking guardianship of the child or youth and gets these specific findings.
I have a question.
Yeah, of course.
Does this apply to the dreamers too?
If, so just to give folks who may not be aware, the dreamers is kind of a common colloquial term that we use for children and youth who have been brought to the United States by their parents and don't have status. The DREAM Act never passed, and we don't really have anything besides DACA. And so I would say for those children and youth or young adults who can get a guardianship order about them before their 18th birthday, can get a custody order from one of their parents related to them before their 18th birthday, or if they're in dependency and neglect proceedings, can get an order from the family court judge saying these specific three things, in number 3, 4, and 5, then yes, that child or youth could qualify for SIDGE, which would be a better option for them than DACA. But if they're 30, they're not going to qualify for this, or even if they're 22, they're not going to qualify for this. It's very age and situation limited, unfortunately. So just some things to keep in mind. For children and youth who have just arrived in Delaware, unless the court has emergency jurisdiction, they're not going to be able to, have a parent or family member seek custody or guardianship until they've been here for 6 months. So there can often be jurisdiction issues that come up. There are often age out issues that come up, and the reason I'm flagging this for you all is to kind of be on the lookout for this, because it's really hard when we get a call from OCA or CASA or DFS saying, we have a 17-year-old who's about to turn 18 next month and we think they qualify for SIDGE. Can you help? And the answer is going to be, oh gosh, well, maybe, maybe not, let's try. But it is very difficult to get anything quickly, that quickly before a child or youth ages out on their 18th birthday. So just kind of be on the lookout for age and things like that. And another issue that we see less often in dependency neglect cases, more often in custody and guardianship cases, is being able to notify the parents if they're not in the country. And that's for children and youth who are kind of here by themselves. How do we serve parents who are in Guatemala or Canada or wherever they may be? So there are some difficulties with that as well. So some of the benefits of SIDGE, as soon as you file that petition with the family court order and you get receipts from immigration recognizing that you filed that, that child is automatically eligible for Medicaid and CHIP. And that is really huge because many undocumented or immigrant children living in foster care don't qualify for Medicaid and can't get things covered. And that means DFS has to pay out of pocket for medical care, dental care, things like that. So this is really kind of a huge carve out to support children and youth who are in foster care and get them medical coverage that they might need. So there's kind of a push to get this filed quickly so you can get those receipts and then go to social services and get Medicaid turned on for them. Once the SIDGE petition is approved, the child is able to apply for permanent residency. And while their permanent residency or green card application is pending, they have the right to ask for a temporary work permit. Now, does a 14-year-old have to work? Are they able to work? No. But a work permit is a good idea because it's another form of photo ID. It also lets them get a social security card and number and lets them go and get a state ID or a driver's license, depending on their age. So the ability to get that work permit is really helpful for identity and social security purposes, even if the child is not able or eligible or wants to work. Once the child gets permanent residency, they have the right to live, work, study in the United States permanently. They also have the right to eventually become an American citizen. They can go through that naturalization process. One important thing to keep in mind, if I am a child who gets approved special immigrant juvenile status, gets an approved green card based on that SIJ, and then I become a citizen, I cannot turn around and sponsor my parents. Even if it's, my mom is the good parent and my dad is the abusive parent, I can't sponsor mom through a family petition to get status in the United States. She can get status a different way, but she can't get status through me. And the reason I raise that is for many youth, it's important for them to have their non-offending parent become documented and get status as well. And so that's why a U visa might be a better option for that child or youth than special immigrant juvenile status. And then to just touch on Joyce's question about timing, for SIJ, it's a little faster, and I'm using, sarcastic air quotes intended because nothing is fast with the federal government. SIJ cases, those petitions are supposed to, by law, be adjudicated within 180 days. We're getting back to that time frame, but we're not there yet. But under the prior administration, it was taking sometimes 2 to 3 years to adjudicate those cases. Right now, I would say we're getting them between 9 months and a year. So we're getting back on track, but it's certainly not quick. And then, permanent residency can take, 1 to 2 years. So is it faster than a U visa? Yes, but is it fast, period? No. So that's another thing to keep in mind with children and youth, kind of what are their goals as far as working, going to college or university or trade school, and would SIJ benefit them and help with that goal better than a U visa?
I have a question.
Mhm.
When you say get back to normal, you're talking about because of COVID effect or because of some other effect?
I would say both. I mean, I think, they're victim-based cases under the prior administration were not prioritized.
Okay.
And so the processing times came to a pretty screeching halt. That was exacerbated by COVID, particularly in 2020. When things started opening up again in 2021, they were able to pick up the pace because officers, adjudicators were returning to work. But, I think there was a slowdown based on priorities in the prior administration that was made even worse from a client perspective by COVID. I think the current administration has prioritized victim-based cases and is putting resources back into that unit. And obviously COVID is not behind us, but we're learning how to deal with it a little bit better. So I think those two things have helped kind of pick up the pace from a processing time standpoint. All right, good questions. And we have, 10 minutes. This goes quickly. I just want to touch briefly on VAWA and T visas. You're probably not going to see a lot of these, but I just want to flag it so you can be on the lookout. And so it kind of perks up your ear if you hear any facts that might fit. The Violence Against Women Act replaces family sponsorship cases by letting a survivor of family violence petition for status without the help of their green card holding or US citizen family member. And so just to give you a kind of quick overview, if I'm a US citizen or a permanent resident, I can sponsor my spouse, my child, my parent to get status in the United States. And for obvious reasons, if I'm abusive, that makes things difficult for the victim family member. And so VAWA kind of takes the abuser out of it and lets the victim prove their case on their own. And so this would be for children and youth who have a US citizen or permanent resident parent who has been abusive of them. So you have to show for VAWA that you have a qualifying relationship with that US citizen or permanent resident. And that means I'm the biological, adopted, or stepchild of someone who is a US citizen or a lawful permanent resident. I have to show that they have that status. I have to show that they abused me, and that can be physical, emotional, psychological, or sexual abuse, that they abused me, and that I, at some point, lived in the United States with that abusive family member. And then last but not least, I have to show that I have good moral character, which is what Gerald was talking about with kind of criminal and, gang affiliation background. And so if I can prove those 5 main things or requirements, then I am eligible to get an approved VAWA self-petition. And just like SIDGE, I'm able to apply for permanent residency. And while I'm waiting for that, I'm able to apply for a temporary work permit. Once my residency is approved, depending on my parent's status, I'm able to apply for citizenship in either 3 to 5 years. So again, the important thing to think about with VAWA is, does the abusive family member have the right kind of status? If my father is abusive, but he's undocumented, I'm not going to be able to qualify for VAWA. I might qualify for SIDGE or a U visa, but I'm not going to be able to qualify for VAWA. And the timing of VAWA is pretty similar to what the SIDGE timing is. So VAWAs are decided in about 18 months, VAWA petitions, and then the permanent residency in a year or 2 thereafter. So you're looking at like 1 to 3 years. So fairly equivalent to special immigrant juvenile status processing times. And then last but not least, the T visa is available to victims of trafficking. It's a lot like the U visa in that it was to give law enforcement officers and the criminal justice system kind of a tool to encourage trafficking survivors to cooperate with them. So it's a law enforcement tool, but it also provides humanitarian relief. You might be noticing a pattern here. There are 4 main requirements to qualify for a T visa. I have to show that I'm a victim of trafficking. And what that means is I've been recruited or brought to the United States physically by either force, so I've been physically dragged here, by fraud, meaning under false pretenses, or I've been coerced to come to the United States with the intent of the person doing that force, fraud, or coercion being to force me into labor, which includes the commercial sex industry. So bringing me here with the purpose of forcing me to engage in labor. The second requirement is I have to show that I'm physically here in the United States because I was trafficked. And if I'm under 18, the third requirement, I don't have to cooperate. If I'm an adult now, meaning over 18, I have to demonstrate, like with the U visa, that I've been cooperative in the investigation or prosecution of the traffickers. And then the last requirement is I have to show that I was a victim of because I was a victim of trafficking, I've suffered hardship, and I would suffer hardship if the government sends me back to my home country. And that can be anything from it's not safe if you send me back to my home country because the traffickers can retaliate against me, to, here I can get mental health counseling or sexually transmitted disease services, medical care that I would not be able to get in my home country. So it's kind of a broad scope look at what hardship means and what qualifies as hardship. Exactly like the U visa, the T visa gives me 4 years of status, a work permit for those 4 years, which gets me a social security card, driver's license or ID. And it allows my non-offending, so my family members who are not in any way involved with the trafficking perpetration or perpetrating that crime against me, it allows them to become derivatives on my case. So whether they're here or somewhere else, they can get status. And it's the same thing as the U visa. My spouse, my unmarried children, my parents, depending on my age, and my unmarried siblings, depending on their age and my age. And exactly like the U visa, 4-year status, but in my 3rd year, I'm eligible to apply for my green card. The T visa is under, federal circumstances, very fast. T visas take about 12 months to adjudicate. The cap is never met, so there's no backlog. And so if I qualify for a T visa, it's going to get me status much more quickly than a U visa or SIJ or VAWA would get me. And I think it was Joyce. Did you have a question?
Well, I did, but I think you answered it because you said within that 4 year, the 3rd year, you can apply for you can apply for permanency.
Yeah, permanent residency. Yeah, it's like
Permanent
permanency,
residency.
a little different, but yeah, it's a green card. Yeah.
Okay, so because they all have this 4 year limitation, what happens after the 4 year?
So in year 3, so once you hit your 3-year anniversary, between year 3 and year 4, you submit a new application for permanent residency for your green card. And that's
Okay.
when immigration does another background check. They check and make sure that, while you were here in your U visa or T visa status, did you engage in any criminal behavior or anything like that? And if not, your permanent resident card or your green card will be granted. And you can be a permanent resident or have a green card your whole life, or you can choose to apply for citizenship. So the way I tell clients and folks to think about it is there's that first step, which is U visa, T visa, SIJ. And then there's the next step, which is, okay, now that you've got that, now you can apply for permanent residency or your green card. And then once you have that, the final step, if you want, is to apply to become an American citizen. Because you have to have a basis or a reason to get a green card, and you have to have a green card to apply for citizenship. So it's kind of, one after the other, if that makes sense.
Yeah, thank you.
No, absolutely.
Hi, this is Bethany. Is there, with the delay on green cards, would they ever have to reapply for the U visa or the special immigrant juvenile status if the green card's taking longer than the 4 years before it expires?
That's a great question. What counts is the date that it's filed. So your age and your application date are locked in the date that it's received by immigration. So if I apply, what's today, the 23rd, let's say my U visa expires on June 24th of this year, and I file my case yesterday for my green card, and immigration clocks it in and receives it today. Even if it takes them 5 years to adjudicate my residency or my green card application, it's locked in and timely because it was received today before my status expires. Same thing.
So with the EAD, then, if it has that expiration date on it, they would just have to be able to show that they have a pending green card application. Got it. Okay.
Yep, absolutely. And there are kind of new rules that the current administration has pushed out, because work permit renewals are taking, EADs, employment authorization documents, are taking a long time for them to process because of this backlog. So even if I file to renew my work permit, the Biden administration has basically issued a memo to employers and DMVs saying, if they timely filed and had a valid status, it's not their fault it's taking this long, give them over 360 days automatic extension just by this notice. So they're trying to kind of help clients and deal with this, recognizing that, the backlog is causing people to lose jobs and things like that.
Can you say what EAD is again?
Absolutely. Bethany knows the lingo.
Yes.
It's employment authorization document,
Okay.
which is a work permit.
Okay.
All right, and we are right at time. Lauren, what do you propose we do? Should I open it to questions? Should I try and touch on some key points?
How about we could touch on some key points?
Okay, perfect. And if folks need to leave, I will not be offended at all. I got thick skin and I know we're out of time, so totally fine. I talked about 4 types of cases. There are a whole host of other types of cases out there. I think Marie talked about Dreamers or DACA. There are other types of cases out there that we might not be able to help with, but that other agencies or immigration attorneys might be able to. Obviously, there are employment-based cases where an employer can sponsor someone. There are family-based cases, which I talked about earlier, where a US citizen or a permanent resident can sponsor their family members. And then there are humanitarian-based cases. Just to give you a quick overview of family-based status, this is also not quick. If I'm a US citizen petitioning for my sibling, there is a backlog going back to the 90s for cases, depending on where my sibling is from. Read, if my sibling is from the Philippines, China, India, or Mexico, we're looking at an over 20-year wait.
Wow.
So when folks in the news talk about, people just need to get in line, for many of our clients, there isn't a line for them to get into. And even if there is, that line is long and it is not going to it's not going to move quickly. And so it's complicated and it's slow. And so it's just something to keep in mind when we think, well, why hasn't this person gotten status? Usually it's not because they haven't tried, it's because there are huge time and complicated barriers that may not make them eligible. I think it was Joyce that asked about, Ukrainian refugees. I talked about asylum being for people who are refugees but are here in the United States. And again, that's people who can prove that they have been persecuted by their government or groups that their government can't or won't control because they're in a protected class. It's fairly difficult to qualify for asylum. You have to prove all of these elements. Just living in a country where there's generalized violence is usually not enough. Gang activity in El Salvador might mean that other people that I know in my neighborhood have been killed by the gangs, but that doesn't mean I'm going to qualify for asylum. They're not seeking me out or didn't seek my neighbors out because they're of a certain race or religion. It's just generalized violence. So asylum is a bit more complicated than it sounds to qualify for. If someone has asylum, that's like the other cases we talked about earlier, a path for them to go to step 2, which is applying for permanent residency, and then go to step 3, which is citizenship. And then last but not least, temporary protected status and DACA. So TPS is temporary status that is granted to people who are in the United States and can't go home because of certain country conditions. Most recently or timely, kind of current event wise, this is people who are here from the Ukraine. They can be granted temporary protected status, which is a 2-year work permit that lets them stay here until things become safe for them to return home. So you have to be from one of these countries, and Ukraine is the most recent one that should be added here. You have to be from one of these countries and in the United States. But I just want to be clear that this is temporary, hence the T in TPS. This is not permanent, and this doesn't let you, like the other cases we talked about, apply for permanent residency in step 2 and apply for citizenship. This is just a kind of, while you're here short term, you have the right to work, and that is it. So it's really not a long-term path or status.
So when we had the Afghanistan refugees come over before the Ukraine, what happened with their status? I mean, they have to go through all this as well?
Most of the folks who came from Afghanistan after war broke out in August came in as refugees. So they were designated abroad as refugees. They were relocated here, and they're eligible to apply for permanent residency after they've been here for 1 year.
Okay.
For Ukrainians who are designated as refugees, the same thing would apply to them.
So, but the status of, doesn't that allow them, so they get aid and stuff like that, the medical and financial
Absolutely,
benefits?
yes. So refugees and asylees are kind of treated, they're given kind of special status, that they get some supports when they get here for 1 year. They can get benefits, and then they can apply for permanent residency. People who have TPS, that's for people who are here, and it gives them temporary status, but it doesn't give them, Medicaid or housing or anything like that. It's just a work permit.
It's work.
And so for someone who, comes in from the Ukraine or is from the Ukraine or Afghanistan, they certainly can, if they're coming in as a refugee, go the route of applying for residency. They wouldn't want to switch to TPS. If they're already here, they can apply for asylum to not have to go back to their home country, or they can apply for TPS or both, with TPS kind of being the lesser of the two statuses. And DACA is the exact same way. DACA is not really status per se. It's basically, we recognize that you were brought to the United States before you turned 16. You've been here since 2012, or 2007, excuse me. You're in school, you're in the military, you've graduated or gotten your GED, and you're under 31 years of age back when President Obama, former President Obama, declared this executive order. Obviously, there's been a lot of litigation between 2012 and now about whether DACA is legal, whether it should be legal. It's gone back up and down to the Supreme Court. And I will just cut to the chase and say the most recent, iteration of DACA is it's still pending. It's on its way back up to the Supreme Court. At this moment, DACA means if I had DACA before, I can keep renewing it, which is every 2 years, I submit an application to get an EAD or a work permit that lets me live and work in the United States, but it doesn't let me apply for a green card. It doesn't get me anything else. It just gets me a work permit. I can keep renewing it under the current kind of limbo status. If I never applied for DACA before, the current status of the Supreme Court case doesn't let me make a new application. So basically everybody who had it and was grandfathered in can keep renewing, but new people, you're out of luck for now, is essentially the too long, don't read point that I want to make here. So it's not a long-term amnesty for any of these children or youth. I just want to give you some overviews of resources to look at. There's a video that I have linked here that I would highly recommend you all watch. Usually folks kind of tear up because it's pretty moving. Children, non-citizens, and that includes children and youth, you have the right to counsel if you're in deportation or removal proceedings, but at your own expense. And what does this mean day to day? It means on any given Thursday when I'm in immigration court in Philadelphia, there are 5-year-olds who are trying to represent themselves. It is abhorrent. Much of this is complicated stuff. It's legalese, and to think that someone who is new to this country and maybe doesn't speak English can represent themselves is ridiculous, let alone someone who is 6 or 5. And so the video kind of captures what that really looks like and how preposterous that is. The other thing is these applications are not short. They involve legalese like moral turpitude and good moral character, which most lawyers have to look up. So it's really not a pro se user-friendly process, especially not for children or youth. And then I'm going to skip to the last slide and just kind of give a plug for working with interpreters. A lot of these children and youth, English may be their second language, or their parents might have English as their second language. And it's important, and in order to comply with the law and be legal, that we use qualified interpreters. There are certain provisions in the law that say if your agency or the agency with whom you work receives federal funding, you have to provide language access. And that means an interpreter, whether it's a Spanish interpreter, an American Sign Language interpreter, but you can't give lesser services to someone because they're limited English proficient. It's also important just because communication is so important in these cases. And if you can't communicate effectively, you can't be an effective advocate. And Google Translate or, the 5-year-old child are probably not good ideas to use as interpreters. I mean, have I looked up words on Google Translate? Absolutely. But it is not, a robotic interpreter that's effective in communicating with clients, especially about sensitive issues like dependency, neglect, abuse, sexual assault. There are resources available. The state has contracts with Language Line, and that includes all the law enforcement agencies and DFS to provide these kind of on-demand services. And that's especially important for languages that are really not common or popular. Most agencies have someone on staff who speaks Spanish, who's bilingual in English and Spanish. But Mom, which is a language spoken in parts of Guatemala, probably not. Creole, maybe not. And so that's why it's important to know what resources are available to you ahead of time, so you know who to call and how to get an interpreter on Zoom or on FaceTime or on the phone, so you can effectively communicate with a child. And the other thing I would say is, think about an interpreter as kind of a microphone or a mouthpiece. It can be a bit of a conversation blocker when you say to the interpreter, tell the child that the next step is blah, blah, blah. It's much more effective to talk to the child or the youth as though you're talking to them. So speak to them the way you would an English speaking client and let the interpreter do the interpretation. So you're speaking in the first person or directly. It really is helpful to provide that connection and provide them with the same level of services that you would an English speaking child or youth client. All right, so we're 12 minutes over. I apologize. My contact information is here, including our 3 offices, the main numbers. You're welcome to reach out to me. You're welcome to reach out to the offices. If you have questions, if you want to make a referral, Lauren will be sharing these slides with you, as well as our immigration brochure. Feel free, which is in English and in Spanish. Feel free to distribute far and wide, friends, enemies, neighbors, fellow CASAs, all of the above, because it's really important that we kind of identify the needs for these children and youth before they age out and get them status if it's possible. So with that, I will stop talking. If anybody wants to hang out and ask questions, Lauren, I'm fine with that if you are.
Sure.